The second case on this morning's docket. That is case number 106021, State of Kansas v. Lovis Todd.
Good morning. Mr. Todd appears through counsel Michelle Davis. And Mr. Chief Justice, may I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you. This is a case where Mr. Todd and a couple of other individuals, the state alleged, went to rob some individuals inside a house, that there was a shooter outside the house and that Mr. Todd was the shooter inside the house. And the state's case rested on the testimony of 3 individuals who provided evidence that Mr. Todd had committed this crime. 2 of the individuals were people who had been inside the house, and so one of our issues goes to the fact that was eyewitness identification testimony. Neither of those individuals had seen Mr. Todd before. And so one of the issues in our brief is that the court instructed with the disapproved of degree of certainty instruction, and that was error to do so. And then our other issue goes to the 3rd individual who provided testimony against Mr. Todd was an accomplice by the name of Alexander. And she was a woman who arrived at the house with the defendants. And the district court never instructed the jury to consider her testimony with caution, which is what you're supposed to do with accomplice testimony. And then Mr. Todd's defense in this case was an alibi defense. There was testimony that he was with another individual, some other individuals at the time that the crime was committed. And so our other issue is the in closing argument that the prosecutor had said that witness wasn't credible, and the way that the prosecutor had attacked that witness. And given that that was Mr. Todd's defense, that was prejudicial. So I think basically in this case we are alleging several small errors. And probably our best issue in terms of reversal would be a cumulative error claim, that because of all of these different errors that Mr. Todd did not receive a fair trial. And
all of the instruction complaints would be under the clearly erroneous?
Yes, yes. So
about the eyewitness instruction and its reference to witness certainty, was there any testimony by either, it's Jones and McFarlane, correct?
Yes.
The 2 witnesses. Was there any testimony on their part about how certain they were of their ID?
McFarlane particularly, because McFarlane was the individual who had changed his story about his identification. Initially the preliminary hearing, and then in his testimony, in his identification to police, he had said that Todd had been the shooter outside the house. And then at trial, he said, no, Todd was the person who had entered the house. And so defense counsel really questioned McFarlane on that. And McFarlane stuck to, I was mistaken before, but I'm correct today. And so it would be our assertion that that is an expression of a degree of certainty.
Okay,
that
but
I
there
was
wasn't
wrong
a
before.
there wasn't a specific percentage, or some of the things we sometimes say about certainty where I'm 100% certain or I'm 50% certain. There wasn't any of that kind of quantification of certainty that we see sometimes.
Just more general, that,
Yeah.
you know, I'm correct today.
How
type
about
thing.
Jones?
Jones, again, just we would assert that he expressed no equivocation in his identification. And
Was he asked?
Because he testified he'd never seen Mr. Todd before. So again, he was subject to some pretty strict cross-examination, and that he was sure it was Mr. Todd type testimony, and not quote exactly, but, and we believe that that's enough to quantify as expressing a degree of certainty. And then, of course, the question for this court is how significant was this a critical aspect of the prosecution's case? And was there a serious question about the reliability of the identification? And again, with McFarlane, given his different identifications, pre-trial and then trial, that we would assert that there is a question there about his reliability, and the same with the other individual.
Is the word we've been using crucial testimony? Was it crucial to the state's case? I think that's
Critical aspect?
Okay. And even with Alexander's testimony, your assertion is that these 2 gentlemen were critical aspects of the state's case?
Well, again, I think you have to look at this as a totality, and that given that that the accomplice instruction wasn't given, and the state keeps bolstering each witness based on the other witnesses, but with each witness we have error. And so if you can attack each of them, then it definitely undermines the state's case. But I would acknowledge this wasn't just a one witness identification sort of case. There were 3 people here.
Thank you. And she was familiar with the defendant from childhood.
Yes, yes.
Thank you.
And then on the prosecutorial misconduct, if I could shift gears, the characterization that we objected to was when the prosecutor said that the alibi witness would have preferred to deceive you, that there's no basis in the evidence for that, and that this was prejudicial. And the prosecutor did some correct things in that closing in terms of the prosecutor said, well, you can't, what she's telling you isn't credible. Her story doesn't make sense, that where she went to this location and then they picked her up later, how that doesn't make sense, and that doesn't make her credible, and that's fine. But then by the prosecutor directly saying she's not credible, and the personal attacks on her are what we objected to, and that she had a duty to come forward prior to the trial. She had a duty to come forward and talk to law enforcement prior to the trial because she was an alibi witness, and not just wait for the trial, that was improper, because of course there's no duty on a defense witness part to come forward prior to the trial. And because this was gross and flagrant, because this was the heart of the defense. This was the only defense, pretty much. That would conclude my comments, unless there are questions from the court.
Any further questions? Thank you, counsel.
Thank you.
May it please the court, Ed Brancart, Chief Deputy District Attorney from Wyandotte County, appears for the state. Your Honors, the strongest argument that I can make on all of the issues raised is that the facts in support of this conviction are incredibly strong. There's lots of evidence that this was a robbery, an aggravated robbery, and in the course of that, Mr. Green was shot and killed. And frankly, there's strong evidence that he was shot and killed by Levis Todd, shot additionally by yet another one of the robbers. The other point I think I should make clear or stress is that the defense was all in on the defensive alibi. There were no objections to or arguments made about any of the other aspects. It was they really did an all or nothing defense, and then the lack of objections for any of the things that were complained about. We'd acknowledge that there's been some activity in this court since we wrote the briefs that might affect some of the outcomes. Certainly some of the arguments that we made, and we would respond that to some of the arguments of counsel that there was no percentage of certainty asked for or expressed by the witnesses. And to the extent that the misidentification at a preliminary hearing was corrected by Mr. McFarland at the trial, that was the subject of full cross-examination, which tends to get at the issue that the instruction would have told the jury about. Plus, there were other instructions that were given that tend to cure any problem there. Certainly the credibility of, the general credibility of witness instruction was given. And we think that both parties argued argued the issues in their briefs substantially. I don't have a lot of ground to cover beyond those, but certainly stand for questions.
Any questions of counsel? Thank you, counsel. Reserve 3 minutes for rebuttal.
I would waive rebuttal.
Any objections to counsel waiving rebuttal? Any more questions? Thank you both for your arguments this morning. Clerk will take this matter under advisement.